Thank you, Mr. Preston. Yes, Mr. Field.
May it please the Commission. Mr. Preston, can I ask you to turn to paragraph 230 of the statement. It's on page 86, and the paragraphs following that. And this is in response to the schedule you received with your summons. You see there in paragraph 231, you're acknowledging knowledge of friendships between Mr. Murray, Mr. Hume and Mr. Connolly. In 233, you use the expression, I too was friendly with Mr. Connolly. It's the case though, isn't it, that he was a friend of yours?
A friend through a professional relationship. We had a friendly relationship. But as I indicated, we weren't friends who socialised on a regular basis outside of work.
you didn't socialise on a regular basis outside of work. But my real point of my question is whether you regard them as a friend.
Yes, I wouldn't disagree with that.
Now, it is also the case, isn't it, that you knew that Mr. Murray regularly went crayfishing with Mr. Connolly,
Yes, I did.
and that also Mr. Hume regularly went fishing with Mr. Connolly.
I don't know if I knew regularly. I knew he had been fishing with Mr. Connolly.
All right, and you were aware of a number of fishing trips that either Mr. Murray or Mr. Hume and Mr. Connolly attended throughout the time you were employed by the Crown Group.
I think there was a small number, but there were more than one.
And some of these were not merely day trips; they were overnight or extended trips to Jurien Bay, for example.
I recall a trip of that nature. Yes.
And to the Mackerel Islands.
Vaguely recall.
And it was also the case, was it not, that at the end of each crayfishing season, Mr. Connolly would put together a video and distribute it to you, Mr. Murray and Mr. Hume.
Oh, I don't recall the video, sorry.
I ask you to, I could just show you DLG .8001.0030.0647.
Yes, I see that.
Yes. Now, does that refresh your memory as to the production of what Mr. Connolly describes as a movie masterpiece of the crayfishing season?
I can't recall the video.
He posted it on YouTube.
I can't recall the video, so
All right.
I'm sure it was posted, but that seems to be not unreasonable.
But you look forward to critiquing it.
Yeah, I would indicate that I would be watching it.
And again, you've used the expression there, mate, haven't you, in your
Yes.
communications with Mr. Connolly. From approximately what point in time would you describe your relationship with Mr. Connolly as developing to one of friendship?
I couldn't give you a time period. I've had an association with Mr. Connolly through his role at the department since I started working at Crown, really.
All right. So would it be fair to say that via your interactions with Mr. Connolly over that time, you developed a friendship?
Yes.
And it's also the case that Mr. Connolly communicated with you in a manner that indicated he extended his friendship to you.
Well, he communicated with me on a personal basis at times, yes.
So if I could just ask for the document CRW .705.002.2258 to be produced. This is an email chain involving you and Mr. Connolly from September 2012. And you'll see that Mr. Connolly is extending an invitation to Mr. Hume, Mr. Murray and yourself to go fishing on the Good Ship Compliance, about halfway down the page.
Yes.
And so that again, you'll see that Mr. Collins dealing with you in a matter of friendship, really.
Oh, he's inviting me on a fishing trip, yes.
Yes, and your response is looking forward to it, Mick, and there's obviously a misspelling of Mr. Murray's name, and you've said, I get the sense the skipper has been on the run. So that's, as I described earlier, something of banter.
Yes.
Indicating again there's a friendship between you and Mr. Connolly.
Yes, I would accept that.
So that we could say certainly by at least the end of 2012, your relationship with Mr. Conley developed a friendship.
I'd accept that.
Now, Mr. Murray reported to you in your role with Crown Perth throughout this period.
Yes, you did.
And Mr. Hume, whilst he was employed, also reported to you, did he?
Yes, you did. For until about 2017.
Okay. Now, did you encourage Mr. Murray and Mr. Hume to develop friendships with Mr. Conley in that time?
Well, Mr. Hume had been a friend of Mr. Conley's. They were both, I believe, government inspectors together when the casino first opened or thereabouts. So they'd known each other a long period of time. I encouraged my staff to have very positive relationships with all the regulators. In terms of encouragement, I wouldn't say I overtly encouraged them to be friends. However, that relationship developed, and I supported a good, open, positive relationship between my staff and the regulator.
All right. Now, would it be fair to say that as you became aware of the development of friendships between Mr. Conley and Mr. Murray and Mr. Hume, or you knew of Mr. Hume's, insofar as you were concerned, there was no reason for them not to continue to develop those friendships?
No, I held Mr. Murray and hold Mr. Murray in high regard as a professional with strong integrity, as do I with Mr. Hume and Mr. Conley, and I had no reason to believe there was anything inappropriate with those friendships.
Would you accept this general proposition that a relationship of friendship between parties can extend to a sense of loyalty between them?
That's a possibility, yes.
And in circumstances where one of the parties involved is either the chief casino officer or the deputy director of the department, and the other is a person who has responsibility for regulatory responsibility within Crown Perth, there is the potential for divided loyalties where those parties are friends.
Oh, there's the potential.
And there's also, from a perception point of view, from the public perception point of view, a recognition of the potential for that divided loyalty.
Perception, perspective, yes, I agree with that.
So whilst you may not have yourself had any concerns about the integrity of those people involved, you would accept, would you not, that from a perception point of view, the public could be concerned about divided loyalties?
From a perception perspective, yes.
And given that, do you consider it appropriate for the casino licensee in Western Australia to have permitted relationships of that nature to continue throughout the period that you were overseeing Mr. Murray and Mr. Hume?
Well, I never saw any evidence of anything inappropriate, and as I said, my observations in dealing with these gentlemen over a longer period of time, I held them in very high regard. And the concept of having friendships, I was not uncomfortable with it because I encouraged strong relationships with regulators. If they developed to friendships, I wasn't adverse to that. The activities that were being undertaken were disclosed, and I understand they were disclosed at the regulator as well. So that gave me enough comfort that it was an appropriate course of action. But having said that, from a perception perspective, I accept what you're saying.
Well, just to look at it from the public perception perspective, Mr. Conley, Mr. Murray, Mr. Hume, and you were in operations meetings together regularly, and at least Mr. Murray and Mr. Hume were regularly fishing with Mr. Conley. Was there any point in time where you considered that given the perception that could result from that the friendship should be placed on hold, or the people should not participate in the operational meetings?
Well, the operation meetings were with various other people as well, other representatives from the regulator, which changed over time, and also other members from the Crown team as well. So it wasn't just the four of us meeting. I never observed anything in terms of inappropriateness, but again, as you've suggested, from a perception perspective, I accept that from perception perspective, it's not ideal.
Was that arrangement consistent with what you understood the Crown Perth Casino conflict of interest policy to be?
Well, there was a disclosure of the relationship, and if I recall correctly, it was disclosed and it was in accordance with that disclosure requirement.
To whom was the relationship disclosed?
Which relationship?
Well, let's take your relationship with Mr. Connolly. To whom did you disclose that relationship?
Well, the business knew I had a relationship with Mr. Connolly. They knew that I had a professional relationship with him in a friendly sense. In terms of Mr. Murray had disclosed that to me and to Mr. Felsted, and Mr. Hume had a relationship as a friend with Mr. Connolly for a very long period of time before he worked at Crown.
Do you recall an event in 2015 whereby Mr. Murray purchased a boat from Mr. Connolly?
Yes, I do.
And do you recall becoming aware of that prior to the transaction?
Yes, I recall that Mr. Murray did notify the business.
And did you have any concern about Mr. Murray purchasing a boat from Mr. Connolly?
Well, there's a couple of aspects to that, one of which Mr. Murray disclosed it to myself. If I recall correctly, I had a discussion with Mr. Felsted to get a sense from his perspective as well. Mr. Murray described, if I recall correctly, the terms of the proposed purchase, which seemed to be commercial from my perspective, not knowing the value of boats. And also Mr. Connolly was disclosing it internally from his perspective. So from my view, the various checks and balances were being ticked off.
Did you yourself contact Mr. Sargent and just have a discussion with him about this?
I don't recall.
Again, from a perception point of view, would you agree with me that the Deputy Director of the Department selling a boat, I should say, to a compliance officer of Perth Crown Casino would create a public perception of the potential for conflict of interest?
In isolation, without the details, there could be a perception of concern, but not with the details as I appreciated them from my perspective.
Were any steps taken on your part to determine whether the transaction was in fact at arm's length?
I was advised of the transaction, and I think I was advised of the cost, and it seemed reasonable to me.
All right. Now, sitting here today, would you accept that the public perception, knowing of the friendships between Mr. Murray, Mr. Hume, Mr. Connolly, and the transaction involving the sale and purchase of a boat, the public of Western Australia has the potential to undermine their confidence in the integrity of the casino operator?
I think that's a very broad statement. I accept there's a perception concern. I accept that. But again, knowing what I knew about them and the circumstances, we didn't perceive it as a problem. But I accept from a perception perspective there would be some concerns raised.
All right. Now, from time to time, was it the case that either yourself or others to your knowledge provided gifts to departmental officers?
No, I don't have any recollection of.
For example, if a departmental officer happened to be dining at one of the restaurants at the casino, complimentary meals or drinks were provided.
Well, I'm going to ask for clarification now that I've heard the question. Very broad, yourself or other members, given the nature of this question, I'd ask Mr Futrell to be very specific, firstly in regard to this witness and then generally in regard to others, rather than wrapping it all up in one.
Yes, take that on board, please, Mr.
Yes, thank
Futrell.
you. So just in respect of yourself, Mr Preston, were there any occasions when that you can recall providing gifts to departmental officers of the crime I've described?
Can't recall.
Were you aware of any other person so doing?
I can't recall.
All right. Now, can I ask you to consider paragraph 234 of your statement under topic 81. And you've referenced there a trip to Macau involving Mr Felsteed, Mr Sargent and yourself. That trip was in 2013.
I believe that's right.
And at around that time, Crown Perth was in the process of attempting to have the government agree to a reduction in the tax rate for the international commission business, wasn't it?
I think that's ballpark time period. I can't recall specifically, sorry.
All right. And so one of the purposes of this trip to Macau was to provide Mr Sargent with some insight into the nature of the competition that the Perth casino was facing from casinos in the region.
Yes, that's correct.
And part of the reason for so doing was to attempt to persuade him to accept that there ought to be a reduction in the tax rate for the Perth casino.
I don't recall there being that kind of discussion related to the direction in that position you're suggesting.
Within the executive of Perth Casino, one of the objectives that you had, was it not, was to educate Mr Sargent about the competition faced by the Perth Casino.
That was part of the reason for the trip.
And one of the reasons that you promoted for the reduction in the tax rate to the government of Western Australia was to increase your competitiveness against other casinos in the region.
To be able to compete, yes, that's true.
So there was a connection then between the trip to Macau to educate Mr Sargent and your desire as an organisation to reduce the tax rate.
I can't recall the timing with respect to the proposals, but Mr Sargent being aware of the nature of the competition is obviously relevant to our propositions regarding ICB tax and
Now,
the ICB business.
You've indicated there that Mr Sargent's travel and accommodation costs were paid for by Crown.
As I recall.
And whilst Mr Sargent was in Macau, was any entertainment extended to him by Crown Perth?
In what respect?
Well, was he taken to restaurants on Perth Casino's account, for example?
If I recall correctly, Mr Sargent paid for his own food expenses.
Do you have any recollection of attending a restaurant by the name of Jade Dragon with Mr Sargent and Mr Felsteed?
Possibly.
Are you familiar with the Jade Dragon restaurant?
The name rings a bell, but I can't recall specifically what restaurant. Jade
Right.
Dragon.
Do you recall whether you attended a show known as by the name House of Dancing Water?
Yes, I do recall that.
And did Mr Sargent attend that with you?
I believe so.
And were the tickets paid for by Crown Perth, to your knowledge?
I'm unsure, sorry.
Now, it's the case, isn't it, that in the end, the GWC supported Crown Perth's submission to the government to reduce the tax rate?
Yes.
During the time that you were an executive of the Crown Perth Casino, you've mentioned earlier that you encouraged your people reporting to you to develop and maintain a good relationship with the regulator.
Yes.
Was there a strategy within the Perth Casino executive to cultivate good relationships with the department that was the regulator, more broadly, not just you, but within the executive team itself?
My expectation of anyone dealing with the regulator, they would be respectful and engaged, and that necessarily drove positive relationships.
And was one of the purposes for the cultivation of that relationship to facilitate approvals of proposals that Crown Perth made to the GWC?
No.
There are a number of decisions made by the GWC, to your knowledge, that involve the exercise of some discretion, correct?
That's
The exercise of some discretion, decision making.
Yes.
And you understand that the process of the GWC was that it received recommendations from members, officers of the department.
Yes.
And did you not consider it advantageous to Crown Perth to maintain good relations between members of Crown Perth staff and the department for the purpose of facilitating decisions in favour of Crown Perth?
No, I didn't.
During the time that you were employed by Crown Perth, would it be fair to say that you had a significant role in making applications to the GWC for approval?
Yes, on particular matters, yes.
You were often the lead person for making the applications and making representations to the GWC?
That was regular.
And when you attended at GWC meetings, were there any occasions upon which you declared your friendship with Mr. Connolly?
No.
You never indicated to them that you considered him to be your friend?
No.
Were there any occasions upon which you provided the GWC members with information about the nature of Mr. Connolly's relationship with Mr. Murray?
No.
Or Mr. Hume?
No.
In the period that you were employed by the Crown Group, would it be fair to say that the vast majority of applications for approval in which you were involved, made to the department, to the GWC, were in fact approved?
I couldn't say.
Are you able to give the Commission any indication from your recollection as to an occasion when an application you made was not approved?
I can't recall. I don't know how many applications would have been made through to the regulator over the years. Some were approved, some were not approved, some were approved with conditions or had to be varied because they weren't satisfactory from the Commission's perspective.
Would it be fair to say that in your experience, and I'm just talking about your recollection here, it was a rare thing to get a knockback?
We had a good number of our proposals approved. And again, our proposals were considered before we actually lodged them with the department for consideration.
I understand that. So coming back to my question, is the answer you consider it to have been a rare thing to receive a negative response from the GWC?
I just can't recall, sorry, in terms of numbers or rarity or not.
I have no further questions.
Right, thank you, Mr. Futrell. Mr. Ramananda?
I think we second row first today.
Oh, who's going first? Mr. Evans.
Looks like to me, Commissioner, thank you. Mr Preston, just a couple of points to clarify. My apologies, yes, I think Mr Preston knows I represent the Gaming and Wagering Commission
Yes, thanks, Mr. President.
proceedings. Thank you. If I could just clarify a couple of aspects of your evidence, perhaps we can move to the last question that was put to you first, because I think you said something in explanation that may have been slightly lost. It was a practice, was it not, adopted over a course of a considerable period of time for officers of the casino and officers of the department to liaise on prospective approvals?
Yeah, that's correct. An important part of the operations meeting was to discuss any proposals, to get a flavour from a regulatory perspective, regulatory input at the outset, to assess whether we would progress with a proposal, whether we needed to reconsider the proposal or not progress with the proposal.
And
Sorry, Mr. Evans, I missed the question. Could you just repeat the question that you asked?
The question was to the effect that there was a practice in place for many years of officers of the casino and officers of the department liaising on a proposed application for approval.
So the question is between officers of the Crown and officers of the department?
That's correct.
Thank you.
Yes. So it is the case that matters which came formally before the GWC for approval had already been through a process in which they were discussed on a preliminary basis
That's correct.
to determine whether they would progress to an approval.
Indeed, I always was of the view that was an important part of our teams, particularly in that operations meeting that we had product development manager and chief operating officer of gaming to get a very clear sense of regulatory concerns or regulatory considerations so they could factor into proposals that might move forward.
And it is the case that a great number of those approvals, perhaps the considerable majority of those approvals, were for the approval of new electronic gaming machines.
But they were the vast majority of matters that went to the Gaming and Wagering Commission by far.
And to put this in context, at the time you ceased to be involved with Crown, the Perth casino had something like 2,500 approved electronic gaming machines, is that correct?
That's correct.
Every one of which required a separate approval?
Every type of machine.
Every type of machine, yes.
And there would have been, I'm not quite sure, but it was probably more than 100 different types of machines or more, and that would fluctuate over the years.
And every change of the rules to those machines required an approval?
Correct, same with table games as well, and variations of table games, and jackpots and the like would require approval.
Thank you. Now, you sat on the responsible Service of Gaming Committee for a considerable period of time, is that correct?
Yes, that's correct.
And you collected on that committee and you received reports on the patrons who played in the casino?
Yes, some statistics, yes.
And I just want to understand a little bit about some of those statistics, just to, if we could. And I'm going to call it two documents, and if I can have those documents brought up on the council's and the commission's and witnesses screen only, it is not on the public feed and not on the large screen.
Sharing arrangement going. Can you still see, Steve?
Can I bring up CRW 700 045 6131? Now, this is a type of report which I think was available in the early 2010s, perhaps around 2014. I haven't got the precise date for it, unfortunately, Mr. Preston. You recognise this type of report?
But vaguely.
Yes. And this lists the top 5 electronic gaming machine players for the month of January, broken in each of 2 groups. And I take it the top group are local players and the bottom group are VIP or foreign and interstate players. Is that correct?
No, I think they're all local. I think there's a difference between VIP 1 and Platinum in terms of tiering, if I'm not mistaken.
So we take it from the club membership that these are all members of the Rewards Club?
It would appear so.
And if I can...
I don't believe the ICB players had what would be referred to as Platinum or VIP 1 cards. I believe they had a a specific ICB card. Same function, but not called those. Hence the reason I think this might be local.
So we take it these are 10 local players in two groups of 5, and they have been ranked in the table which appears by turnover. Is that correct?
Yes.
And if we look under, can we look at the first name in that list? Because I'll concentrate on that for a moment. There's a patron ID, which I take it is the reward club number.
Yes.
There's a club status, and with that status go certain benefits. Is that correct?
Yes, and access to areas.
Yes. And according to that status, you accrue points at a certain rate. Those points can be used to redeem certain benefits,
Yes.
including free play.
Yes.
The turnover figure which is there shown, is that the amount physically bet through the gaming or through gaming machines in the month of January?
Not physically. Well, if I turnover as a concept, if you put money in and you win and you continue to bet, that acts as turnover. So that wouldn't represent that amount of money is going into a machine independently. If that makes.
But it's the amount which is transacted through the machine.
That's correct.
All right. And the stroke, is that the number of games played?
That would appear to be correct, but I'm not entirely sure. It's not my area of expertise.
Turnover divided by stroke leads to average bet by the look of things. Fairly simple arithmetic.
I'll take your word for it.
The number of hours, now this being a member of the rewards system, this is what's called carded play, is that correct?
Yes.
And carded play records the number of hours at which that player spent in the casino in the month of January, actively playing games.
I would expect so.
Yes. The theoretical win, which then appears, is slightly under 10% of the turnover. Now that is that the theoretical house odds?
That's correct.
The actual win is what the house actually won in that month?
That's correct.
So that particular player beat the house but still lost.
Correct.
And the same can be true, therefore, by extrapolation for each of the other players.
That's correct.
And in 2 out of the 10 cases, the player actually beats the house overall and makes a profit,
Yes.
which is denominated by the negative figure in front of the actual win.
Correct.
Otherwise, the win figure is not the player's win figure, but the house's win figure. Is that correct?
The actual win is Crown's win, yes.
All right, thank you. Can I then bring up CRW .700.045.6217? And you have to expand the top table if you can, as much as it's possible. Now, this is a later document. This is a December 2019 report. This is quite recent. It contains slightly greater detail than the report I just took you to. Can I take you down to the 6th row in that table? And you'll see that's the same name that was in the first row of the previous table.
Yes.
And you can take it from me, it is the same patron ID number. The club status is now black.
Yes.
Is that higher or lower than?
That's higher than platinum.
Thank you. And you'll see a turnover figure for that month. Again, strokes, average bet. Again, hours played, which again is carded play hours on the machine in that month.
I only hesitate regarding the actual hours on the machine, in that there are certain areas where people would leave cards in their machine, reserve the machine in the premium areas and have meals, or not be on the machine that whole period of time. For some reason I hesitate in the context of that hour, that statistic.
Yes, because one of the additional pieces of information we have in this case is the number of days played in this case.
Yes.
A bit of mathematics would indicate that that particular player was playing in the casino for 6.6 hours per day.
Yes.
Number of days played in that month.
Yes.
I can accept that. All right, thank you. I'll move on from that. Perhaps we can take those down. Now turn to a different topic. One of your responsibilities, or one of the responsibilities of the compliance team within the casino was to prepare a monthly report which was submitted to the department for the attention of the GWC, which was a reconciliation report. Is that, you recall that?
As I recall, yes.
And you were the signatory to that report from about August 2014.
I think it was prepared, if I'm thinking about the right report, was prepared by finance.
Yes. But for some reason you were the signatory of it?
I think that's a historical hangover as to my predecessor.
Well, your predecessor in that case was Mr. Craig Spence as the signatory of that report.
I was thinking of Mr. Regan.
As I understand it from the documents that we've seen, from up until August 2014, Mr. Craig Spence was the signatory of this report. And what was Mr. Spence's role?
He was CFO of Crown Perth.
And for some reason in August 2014, you took over.
Mr. Spence left the business.
I'm going to take you to one of the, just as an illustration, can I bring up GWC point 0001, point 0007, point 0355? So this is a letter of the 4th of July 2019. Police finding closed in accordance with Burswood Casino directions. It's relevantly direction 4.1C, B and C. A report, and the purpose of this is to submit to the department a reconciliation of the chips and main bank control sheets, which form a principal accounting control for the calculation of gaming revenues. Is that correct?
Yes, as I recall.
And accompanying those is a copy of the bank accounts of the approved banks, or the approved bank accounts for the purpose of main casino gaming.
Yes.
Under regulation 5.1, direction 5.1.
Yes.
And you're the signatory of that document.
I am.
Can I take you down to 35? No, I won't. But I don't have the pinpoint, I don't think, but I'll try and pick it up. Can I take you down to pinpoint 0033? Now, attached to the bundle of banks of reconciliation sheets and bank statements which precede that is a bank statement from the Commonwealth Bank for account number 2000157895881 in the name of Riverbank Investments Proprietary Limited.
Yes.
And that is a Hong Kong dollar account. Is that correct?
Yes, that's correct.
Now, my understanding is that up until this month, that is the July 2019 submission, bank statements for the Hong Kong dollar account with Commonwealth Bank in the name of Riverbank Investments were the only Riverbank Investment accounts attached to these reconciliations.
I recall that came to my attention. I can't recall when. It came to my attention that within the bundle of documents prepared by finance, there had been an omission of some of the other account details. Hadn't been provided.
Well, that's what you say in the next document, which I'm going to take you to, Mr. Preston, which is GWC point 0001.0007.0357. Now, this is the letter of 23 August 2019, and what you just said is effectively picked up in the third full paragraph of that letter, is it not? As discussed with Mr. Paul Hume. Now, Mr. Hume is a former departmental officer who was at the time employed as Gaming and Regulatory Compliance Manager by Crown?
That's correct.
And what for the first time is submitted with this letter, and the pinpoint is 0046. Is a different Riverbank investment account in Australian dollars. And that is a Riverbank investment account which was the subject of the articles in the Sydney Morning Herald and The Age a few days prior to this letter, was it not?
So can I get you to repeat that, sorry, Mr. Evans?
So this is the Riverbank Investments account, which was the subject of the articles in the Sydney Morning Herald and the Age newspaper on the 5th and 6th of August 2019.
I'm not sure they were specific with respect to which account. It was Riverbank Accounts, if I recall correctly.
But it was the occasion of those newspapers which caused you to look at the Riverbank accounts which were being disclosed to the Department of the GWC and to make this production.
Possibly. It would seem to be about right.
And that was the first occasion on which these accounts had been disclosed to the Department of the Regulator.
If I recall, they had originally been disclosed, and then I understand from what I was advised that for some unknown reason they failed to form part of the bundle that Finance were providing to go to the regulator.
From at least April 2014 through August of 2019.
Possibly, that's from recollection what I was advised.
All right. Thank you. We'll move to one final topic. I just finally want to consolidate some of the evidence you gave in response to questions from Mr. Futrell. And this really is in relation to the role of Burswood Limited and its relationship with Crown Resorts Limited. Now, I think it was your evidence that...
I'm sorry to interrupt, but I don't know whether with the names of those individuals there that should be on the public screen.
My apologies, my oversight of it, bringing that up in that form.
Should we make a
non-publication order would be appropriate.
Yes.
There are individuals named.
yes? Because there are individuals named, there is that we'll make a non-publication order. Can you remind me of the number, please?
The number is GWC 0001 0007 0355. No, 357. I brought up the wrong document.
There's a non-publication order in relation to the bank statement, the identifier of which Mr. Evans has just read out.
It's commencing at pinpoint 0046. Thank you, Commissioners. So, Mr. Preston, to deal with this question of relationship, I think your evidence was to the effect that all of the key executives of Burswood Casino in Perth, by at least 2017 and subsequently, had reporting lines to senior executives at Crown Resorts Limited.
No.
No?
No.
Which ones did not have a reporting line to executives at Crown Resort?
All of the key executives in, with respect to Mr. Felstead as at Crown
Yes.
Resorts. So all the executives reported to Mr. Felstead.
Yes. And Mr. Felstead was, although technically domiciled in Western Australia, practically an operationally resident in Crown Melbourne. Is that correct?
He was commuting a lot,
As were you.
as was I.
And it is the case, is that you were the company secretary of Burswood Limited for a very long time. We've read, I think, pretty well all of the minutes that have been put up, that you will not find a resolution of Burswood Limited which approves significant capital expenditure at any time between 2014 and 2020. That actually resolves to spend money.
If that's what the records show, that's what the records
You
show.
don't recall a resolution in which Burswood Limited itself resolved to spend money?
There was numerous discussions in depth about the capital expenditure and what was to be expended. But as to a resolution, I don't recall that.
And that's because capital expenditure decisions were made by the Crown Resorts Limited Board, were they not?
An allocation came from Crown Resorts. This is more of a technical finance piece, but an allocation came from Crown Resorts as to the amount that they were willing to provide to the businesses to spend. The process to determine what that would be spent on was determined by the local Crown Perth executives, which was debated at length, as you can imagine, and then presented to the various boards.
When you talk about the various boards, that is the Crown Resorts Board.
I can't say with respect to Crown Resorts what went to Crown Resorts.
Because when one looks at for example, the development approval for the Crown Towers development, there are development reports presented by Mr Felsted, but there is no resolution to approve those reports or to approve the expenditure.
I can't recall, but if that's what the records indicate.
And there's no resolution to appoint an executive of the Burswood operating businesses?
From Burswood Limited,
Yes.
that wouldn't surprise me.
And there was no setting of key performance indicators for executives by Burswood Limited?
No.
And there was no undertaking of a performance review of key executives by Burswood Limited?
Not to my knowledge.
No, no further questions. Thank you,
Thank you,
Commissioners.
Mr Evans. Mr Ward.
Thank you, Commissioners. Mr Preston, I appear for Mr Poynton. Just following on from those couple of questions that you were asked about the Burswood Limited Board. In the course of your answers to Mr Futrell yesterday, you distinguished between the Burswood Limited Board and the Crown Melbourne Board because the Burswood Limited Board had independent directors on it. You were aware also, weren't you, that the Crown Resorts Board had a number of individual committees of directors that had specific responsibilities for aspects of governance?
Yes, I am.
So you're aware of the Audit and Corporate Governance Committee of the Crown Resorts Board?
I was aware of it.
And you were aware that it had responsibility for the oversight of internal and external audit functions?
I didn't have any activity with that board. Sorry, with that committee.
You were aware that internal audit plans came from Crown Resorts for implementation in Perth?
No.
You were aware of the Responsible Gaming Committee at the Crown Resorts Board level, though, weren't you?
Yes, I was.
And you were aware that it had responsibility for policies across the whole of the Crown Group, including Perth?
Yes.
And you were aware of the Risk Management Committee?
Yes, I was.
And that was responsible for risk management and compliance frameworks across the whole of the group, including Perth?
More focused on the risk framework.
The frameworks, yes.
Yes,
So they were set at the group level?
The risk framework was adopted, but subsequently adopted by the Crown Resource Risk Committee. It was also presented to the Crown Melbourne Board and to the Crown Perth Board as well.
And those committees of the Board of Crown Resorts, they reported upward to the board, to the full Board of Crown Resorts?
They did.
And so when things came down from those committees or from the Crown Resorts Board, they'd already been pretty thoroughly reviewed at group level, hadn't they?
Yes.
And when they were then presented to the Burswood Limited Board in the form of board packs, a lot of care was taken to ensure that all issues had already been addressed.
Yes, I'd accept that.
So unless there was something that was a red flag, you wouldn't expect there to be anything in particular for the Board of Burswood Limited to raise to send back up to Crown Resorts, is that right?
Yes, I agree with that.
And to your recollection, there were no red flags amongst the board packs that you assisted in preparing?
Prepared many packs. There were issues that were raised and discussed, but it depends on what you define as red flags. But the material issues were in there for debate with the Burswood Limited Board.
But those issues were, to the best of the executive's ability, presented with the solutions to them.
That's correct.
Mr Evans asked you about the budgeting. Now, it's the case, isn't it, that the allocation, as you said, was made by Crown Resorts, and then it was, if I could use a colloquial term, fought over by the executives within the various departments.
I believe it was Crown Resorts. I was never involved in the decisions pertaining to allocation, or otherwise I was down the chain. But I understood it was Crown Resorts.
Sorry, Mr Ward. When Mr Evans started that exchange, he referred to capital expenditure, but it seemed that we went a bit broader than capital expenditure, so perhaps that could be clarified.
Yes, thank you, Commissioner. So when we're talking about budgets being, or allocations being set by Crown Resorts, that's not just limited to capital expenditure, is it?
It was capital and operating.
Finally, I just want to ask you some questions regarding the GWC presentation that you were asked about. Can we just bring up GWC 001, sorry, 0001, 0009, 0001? Now, this is the presentation that you delivered on the 27th of August 2019, that's right?
That's correct.
And we then go to GWC 0001, 0008, 0001. Do you recall receiving this email asking you to make that presentation?
Yes, I do.
And that email was dated the 21st of August, so your presentation was prepared fairly quickly between those dates, wasn't it?
Yes, we were asked to prepare pretty quickly.
Can we now bring up CRL 506 006 5576? Thank you. These are minutes of a board meeting of Crown Resorts Limited on the 4th of August 2019. Do you recall attending this meeting?
Yes, I do.
You see Mr Poynton's noted there as an apology. Do you recall him being overseas at this time?
Vaguely.
Can we go to the second page of that document, please? Do you recall the proposal in the second last paragraph on that page that the board establish a committee to deal with the response to the allegations that have been raised?
Yes,
And that was referred to by the board as the Brand Committee, wasn't it?
that's correct.
And that meeting was on the 4th of August. You were then asked to prepare a presentation to the GWC on the 21st, and you delivered that on the 27th. I've got the timing right?
That sounds about right.
So to the extent that you were consulting with the board at all regarding that presentation, you were consulting with the Brand Committee, weren't you?
I can't recall there was another board. There was multiple meetings going on at that point in time. I can't recall there's another board meeting in between, but it was a Brand Committee to a large extent took custody of matters that were running.
Would you accept that there was no board meeting between the 21st and the 27th of August?
If that's what the record shows, I accept that.
Thank you, that's all.
Thank you, Mr Ward. Mr Dharmananda.
Thank you. Mr. President, I act for the Crown Group. Yesterday and today you were asked some questions by Council Assisting about your work in relation to the RGMC. Do you recall that?
Yes.
And that was in conjunction with the delivery of certain statistics to the GWC, and you mentioned that statistics were delivered to the GWC.
Yes.
If I could bring up, please, CRW.008.011.2361. And if we go, please, to 2405 within that document. This notes that there's a delivery with respect to RSD statistic reports for particular months. Do you see that, Mr. Preston?
Yes, I do, thank you.
If we go, please, to the next page at 2406, there's a communication to Mr. Segro about these statistics. If you would be able to assist the Commission about this, the second item in the box concerning behaviour reports. Do you see that, Mr. Preston?
Yes, I do.
So how does this part of the compilation occur? What is this referring to, these various incidents below referrals from licensed casino employees?
This reflects part of staff obligations that they're trained in, that when they're carrying out their duties, if they observe any behaviour of concern, focus predominantly on responsible gaming, but generally speaking, that there's a process to complete a concerning behaviour report, which is then fed into responsible gaming for them to consider and follow up.
And at about the bottom of the box, there's a reference to a section 26.2 issued. What's that a reference to?
That's a Casino Control Act barring notice.
So that's when the casino itself moves to bar, is that right?
That's one of the mechanisms, yes.
And there's, so far as May 2018 is concerned, there's 7 of those incidents you'll see.
That's correct.
Thank you. Now, during your time at Crown, Mr. Preston, to your knowledge, did either the GWC or the department provide any directions on particular steps that Crown Perth should take to improve its RSG framework?
Not that I recall.
And similarly,
Sorry, can I just, what time frame was that?
during your time at Crown?
There was the direction pertaining to the ATM restrictions.
Yes.
That certainly was from, if I recall correctly, from the department or the Gaming Wagering Commission as to the implementation of obligations of the locations and restrictions on ATMs, which I would suggest as part of the RSG framework.
And during your time at Crown, to your knowledge, did either the GWC or the department undertake any specific investigation or analysis on problem gambling issues at the Perth Casino?
Not to my knowledge.
Yesterday, Councillor Sisting asked you about certain matters concerning AML. Do you recall that yesterday?
Yes, I do.
And you explained during the course of your evidence yesterday that disciplinary actions may be taken against employees for non-compliance with AML.
Yes.
And you referred to documenting discussions with employees yesterday.
Yes, I did.
If I could ask you please to go to, and this is again a non-public document, so just on Mr. Preston's screens and council screens, CRW.512.259.0004. If you have a look at that document, Mr. Preston, is that the type of documented discussion to which you referred yesterday?
That seems to be the form of the documents I've seen in times past.
And this discussion concerns what type of employee?
A table games dealer.
And what appears to be the issue as identified in this document?
Failure to comply with AML procedures.
Thank you. You also referred yesterday in answers to questions from council assisting to employees being terminated for non-compliance with AML. Do you recall that?
I do recall that.
Can I ask please again in a non-public screen to go to crw.512.259.0001. Repeat the number, operator. So, without mentioning any names of any persons, do you see that this is a notice of termination of employment, Mr.
Yes, I do.
Preston? Was this matter a matter that was drawn to your attention in November 2018?
It was indeed.
And you'll see at item 2 that there is an investigation of a particular incident,
Yes, I do.
and then there's then consideration given to the dismissal of this individual from Crown.
Yes.
And that was based upon an investigation, and if we could go please to crw.512.259.0005. And if you scroll down, operator, so Mr. Preston can see the date, you'll see that this document bears the date of October 2018 and gives notice of outcome of an investigation and a show cause meeting. Do you see that, Mr. Preston?
Yes, I do.
Would you or anyone in your department be involved in the investigation, or who would be responsible for that?
A matter of this nature would often involve the general manager, legal and compliance, and possibly taking commentary from a person in the AML team.
And would an investigation of this nature involve a review of the video footage?
I would expect that it would have involved video. Matters of these nature, where there's an investigation, often the first port of call is to go to surveillance to see what information they might be able to supply.
And then there would be interviews of individuals who might be able to assist in the investigation.
Correct.
Thank you. You were asked this morning questions around the introduction of FPOS onto the gaming floor. Do you recall that?
Yes, I do.
Do you recall whether at or around the time that the proposal to introduce the FPOS machines onto the gaming floor was being considered, Crown Perth obtained expert evidence from an RGS perspective, RS, responsible gaming perspective?
Yes, I do.
Thank you. Thank you, Commissioner.
Thank you, Mr. Dharmananda. Commissioner Jenkins.
Oh, thank you. Just in respect of that document that's on the page, Mr. Preston, so would what is described there at point 4, would conduct of that nature then, sorry, withdraw that, Was there any guidelines to the staff or management of Crown Perth as to whether any a transaction of that nature should then be reported to the police?
No, it would be, based on what I'm observing in this, would have been lodgement of a suspect matter report.
And so no other law enforcement agency or investigative agency would be advised other than Australia?
No, if they took that path, but no other agency, to my knowledge.
No, sorry, I do have a range of matters to follow up with you. In respect of going back to yesterday to the issue of board governance, take it from me, we've heard evidence from a number of people who have different views about what the role of Burswood Limited was and its relationship with Crown Resorts Limited. In respect of that issue, was there any written document providing advice or direction to Burswood Limited board members as to the role of Burswood Limited
Not to my knowledge.
or their role as board members of Burswood Limited?
Not to my knowledge.
And when a non-executive member of the board was appointed, did they receive any induction or training or information as to what the practical role of Burswood Limited board was in the overall corporate structure of Crown Resorts Limited?
Induction training, and there's only been one new non-exec member in my time. There were various levels to it. Might not be answering your question directly, but there would be induction by meeting with the executives to go through various operational important matters. There was also a role played by Crown Resorts with respect to new board members. I wasn't privy to that, so I can't say whether that covered the issue you're asking about.
In respect, you say you were employed by Burswood Resort Management Limited, and your understanding is that other employees at Burswood Casino are as well.
Yes.
In the time that you were employed, did you ever see a written agreement or memorandum of understanding between Burswood Nominees Limited and Burswood Resort Management Limited as to the role and responsibilities of Burswood Resort Management Limited as the employer?
Only as I mentioned yesterday that I recall seeing a document which provided some commentary on it, but I can't recall the specifics. I think Mr. Futrell referenced the Burswood Property Trust, which rang a bell, but again, I can't recall any great detail. Sorry.
So Burswood Resort Management Limited was the employer. Did it have its own bank account from which it paid employees? Or do you not know?
I don't know, sorry.
I think to your, you would obviously know, Burswood Limited itself did not have any committees.
That's correct.
Do you know why not?
No, I don't.
And we've also heard evidence that the ERCC minutes of their meeting, its minutes, were not provided to Burswood Limited. Do you know why they weren't?
Only to the extent that my views of the operation of the ERCC, which we implemented to assist with the passive information that are being escalated, there are a number of people who are on the Burswood Limited board who were being briefed and privy to all of that information. but I can't recall any reason why we decided not to, even if we did decide to provide the minutes to the Burswood Limited Board.
The ERCC seem to have a lot of responsibilities, everything from compliance, risk, legal, health and safety, internal audit, AML. Did it have too many responsibilities?
It's a big list, I accept, but I thought it was important, as did the rest of the executives, to have a good understanding of all of those key governance-related matters for the business. Yes, a lot of responsibility, but equally so, having all that information, participating in those discussions and decisions was thought appropriate.
In respect of the 2018 Victorian Regulators review of the Victorian casino licence, did you personally take any steps to ensure that the Burswood Limited Board was aware of the recommendations and findings of that review?
I recall having discussion, and I can't recall whether we included in the papers for the Burswood Limited Board all of the details. I just can't recall, sorry. But there were certain discussions regarding the Section 25 review at the board meetings.
And did the board give any directions to management about implementing recommendations made in that review at the Perth Casino to the extent that they were relevant?
Not that I recall. The board instructing management to do that, but my recollection, again, if I'm wrong, I apologise. My recollection is that our position that I would have talked to, and most probably Mr. Felsted or Mr. Alexander, was that the recommendations that were relevant were being progressed with Crown Perth.
At a management level?
So I recall when we were speaking to the board that those matters that were to be implemented, and there was a number of them we would be progressing with at Crown Perth.
But that was at a management level or at a board level?
No, speaking at the board,
At the
board meeting.
And so we could go to the board minutes?
I can't recall that.
Reflected in there?
I can't recall the depth of the conversation or the depth of the minutes, but I certainly recall having a discussion about the Section 25 review and the clear relevance from the Section 25 review to Crown Perth. There's some elements that we were looking to implement at Crown Perth.
Did you have involvement in the submission to the GWC in respect of the removal of the requirement of Perth Casino to obtain junket operator and representative approval in 2010?
Yes, that submission was in my name.
And we've heard evidence that what in fact ultimately occurred was that all of the regulations were repealed, not just those relating to the requirement to obtain approval for the junket operator and the junket representatives. Do you recall that difference?
Between the two?
Yes, that the Crown applied for the removal of the requirement to obtain approval, but that ultimately what happened was that all of the regulations which covered broader issues than that were repealed?
Yes.
And do you recall speaking to Mr. Connolly or anyone else in the department to find out why that occurred?
I don't recall speaking to anyone about it. I may have, but I don't recall speaking to anyone about it. I can't recall the 2010 who I might have had conversations with then. With respect to the 2017, if I recall, it was the removal of the requirement to provide the details of the junket operators and players that were participating in gaming. And I can't recall the specifics of that in terms of what discussions I may have or what my team may have had.
A matter that I don't think you were asked about, and that is that the CUP process that took place in Melbourne.
Yes,
Yeah, I have read your statement, and you say that your understanding is it never happened in Perth. Is that right?
that's my understanding.
But do you recall being contacted by other employees of Crown and asked whether it could happen in Perth?
Yes, I do.
And what was your response? Do you recall what it was?
I have a recollection of what transpired. There was a request as to whether the concept was permissible under the West Australian framework. And this hadn't been something that my team or myself had looked at either for a very long time or ever. But the concept was possible within the existing historical regulatory framework. But it was that historic, it referred to bank card only. But the framework was there. So if I recall, we put a submission to the regulator to seek an approval, not for CUP, but recognition of an amendment to that historical framework. I think we took out the reference to bank card and put in a reference to visas and the like, which are more contemporary. But we never progressed with the implementation of it. We never progressed, as I recall, with the supporting standard operating procedures or changes in the manuals. It was a process to, I suppose, bring into modernisation of the existing framework that was in there.
You didn't have a concern that that process could be used to facilitate money laundering by disguising the fact that money was coming into the casino for gambling as opposed to other services?
Well, we didn't progress with it, and part of the reason was I didn't think it was necessary in the context of what was being proposed. But we thought it was appropriate to upgrade to revisit the historical regulations pertaining to that facility.
If you could just answer my question, did you have a concern that it might in some way facilitate money laundering?
It would have been a concern. I can't recall whether it was my prime concern. It was more understanding. We spent some time understanding the nature of the different providers as to how they could use that facility if we progress with it. In terms of amount of money that could be transferred, how it would be transferred, appropriateness of it to be transferred. That's the reason why we didn't make it just with reference to CUP. It was a general proposition.
In terms of your concern about money laundering, did you communicate those concerns to anybody else in Crown, within Crown?
Not that I can recall.
Can I turn to the Riverbank transactions?
0355. That's 0357.
As I understand it, and correct me if I'm wrong, your position is that the cage staff should have known that they were not to aggregate
Yes,
deposits.
yes.
And how should they have known that?
Well, the training and the standard operating procedures that they had, they should have been looking at these. My expectation is that they would see these transactions and escalate them because of what they appeared to potentially be.
And the fact is that, in 2000, you don't recall any discussions with ANZ Bank in 2014 or
Yes.
around there about this
Yes.
occurring in that account?
Yes, that's correct.
And so your position is that the first time you recall being told about it occurring was when?
The 2014 correspondence was drawn to my attention during the Bergen inquiry.
And you gave evidence, well, was that whilst you were giving evidence or before you gave evidence?
It was whilst I was giving evidence.
Right, so that was August 2020, is that right?
I think it was the first round, so July. I might have gone into August, sorry, so it was the first round.
And was it your view that, your opinion then that the cage supervisor at that time would have been Mr. Brown as when these transactions were occurring?
I believe that Mr. Brown was the manager at the time.
And so when you were told about it, did you contact Mr. Brown and ask him what on earth was going on?
I did.
And what did he tell you?
He was, if I recall, I called a meeting pretty quickly as soon as shortly after I got out of giving evidence, to try and understand what had transpired. And there was no great explanation at that point in time.
And who was present at that meeting, just before we go on?
There was managers from the Crown Perth cage.
That would have been Mr. Brown.
So Mr. Brown or his 2IC, there was someone missing, and their second in charge was there. But I spoke to Mr. Brown and I spoke to his equivalent in Melbourne. So there was representatives from Cage in Melbourne. There was representatives from legal from both Perth and Melbourne. There was representatives from finance from both Perth and Melbourne. There was external lawyers in that meeting, an external lawyer in the meeting, and representatives from the anti-money laundering team as well.
So when you say there wasn't any great explanation, can I just ask you about that? Did anybody in that meeting acknowledge that they knew that?
No.
And that included Mr. Brown?
That's correct. When I say no acknowledgement that they knew, it had been brought to their attention whilst I was giving evidence, if I'm not mistaken. So by the time I stopped giving evidence and convened this meeting, they were aware of the issue. But the information that I got from that group at that point in time, and it was still early in terms of navigating through the history of what might have transpired, no one could give me an explanation as to why it had happened, and no one knew that it was happening.
Now, in respect of that conduct, another matter, a related matter that was identified in the initialism or Grant Thornton reports was that third parties, in the absence of the patron in whose benefit the deposit was made, were then allowed to front up to the casino and withdraw the money or obtain chips to the value of the deposits. Are you aware of that?
The patron taking the money? Yes, I am.
A third party other than the patron being allowed to take out on behalf of the patron.
Oh, not to my. I haven't seen initialism or the Grant Thornton reports, but my understanding was that only monies released would be released to the patron. They would have to be identified, and it would go to the patron. So
you don't have any knowledge of the process that I have just described of somebody on behalf, third party on behalf of the patron being allowed to obtain the value of that of those deposits?
Not unless they were authorised. It could have been, for example, a junket representative who was an authorised person on behalf of a junket operator, but otherwise, I'm not aware. Sorry.
Would you agree with me that permitting third parties, even if they have the authority, well, presumably they would have ostensible authority from the patron, to have the benefit of the deposit, would not be a desirable practice in AML terms?
It certainly increases the risk. Has the potential to increase the risk.
You say that your understanding is that Riverbank was open to be used primarily to provide anonymity to overseas Crown patrons. Is that your position?
I'm not sure. I wasn't there when it was opened.
All right. So I put that incorrectly
Sorry.
because you've made that point. So can I put it like this? When you became aware of the Riverbank account, and to the extent that you turned your mind to it, was that why you thought it existed?
Yes, that reflects my views.
And how did it provide that anonymity? I'm just a bit confused.
I think the concept is that it doesn't have a reference to Crown or casino. So if someone sends funds through on their bank statement, it doesn't have a reference to a casino.
What was the name of Perth Casino's bank account?
I think it was historically Burswood Casino account, and then I think Crown Perth Casino account, or Crown account, I can't recall, sorry.
That might be true for a telegraphic transfer, but for an ordinary electronic transfer on a bank statement, it has the narrative on it that the transferor puts on it. Isn't that right, on an electronic transfer?
That's correct. So they'll put gambling services, or go to the hotel, or whatever their narrative is.
Just saying, I'm just wondering why there would, again, trying to understand why it would achieve anonymity.
Can I just, with respect, interrupt? And I think Mr. Preston agreed with a proposition put to him yesterday that was the purpose. I don't think it was a proposition that he put forward himself. He accepted, in my recollection of the evidence and proposition. I'm not objecting to I'm just putting it in context, Commissioner. My proposition is, it's a proposition that emanated from senior counsel, not the witness.
Well, perhaps I'll ask this question. Did someone tell you that was its purpose? Or did you come to that understanding some other way?
I suspect someone told me, but it's a long time ago.
So you don't recall who it was?
No, it's definitely not.
Was the Riverbank account the only Crown operated or Crown entity operated account that patrons could use to deposit money for gaming?
No.
What other accounts?
The Crown Casino account, which is a separate account. I think I'm not quite sure the specific name, but if I recall, it's the Crown Casino account.
So the main operating account for the casino, the patrons could also deposit money into it for the purpose of gaming.
Yes.
Was there any other account that patrons at Perth Casino could use to deposit money for the purpose of gaming?
Not that I can recall.
Could they use the South Bank account, for example?
Yes, because there were there could be transfers from the Crown Melbourne account or South Bank account to Perth.
So they could also use a Crown Melbourne
I
account?
believe they could, yes.
And the, we've just heard evidence about the Riverbank Hong Kong dollar account
Yes.
and Australian dollar account. Were they two separate accounts?
I think it was one account, but with different denominations. I'm not the banking expert, I suppose. It's a question beyond my expertise.
Do you know whether there were overseas accounts held by Crown that Perth casino patrons could use to deposit money for the purpose of gaming at the Perth casino?
Not since 2012 or 13 or some many years ago they were closed.
So when the evidence was presented to you in the Bergen inquiry about the possible money laundering that was occurring through the Riverbank account, you were aware that there were other accounts that Crown patrons could use?
Yes.
And I think you've given evidence, and there's material in your statement about what steps were taken in respect to ascertaining whether or not the problem was more extensive in the Riverbank account. Did you take any steps to have other accounts audited or inspected to see whether the same problem was happening in those accounts?
That was part of the plan to review. And again, as I mentioned to Mr. Futrell yesterday, I was being removed from those responsibilities to carry out that investigation. I was focused on the Bergen inquiry with further appearances and summons, so I was moved out of that. However, that was the process to be undertaken to review the rest of those accounts once they work through, I think, the first step with Riverbank and South Bank, and then work through the Crown Perth and the Crown Melbourne other accounts.
Just before we leave Riverbank, so after you became aware of the Riverbank account and up until its closure, up until you were advised during the Bergen inquiry of these suspect transactions, that intervening period, did it ever occur to you that the Riverbank account was created a substantial risk of money laundering activity occurring at the Perth casino?
It didn't occur to me that it created a substantial risk.
Even as you're the AML CTF officer, that didn't occur to you?
Well, without controls, yes, but I was satisfied at the time with the controls that were in place to manage that risk. It was being treated, in my view, like any of the other bank accounts that Crown had. But obviously there was certainly a clear weakness, if not a couple.
Moving on then to the issue of responsible gambling. The Responsible Gambling Support Services Committee that committee. Do you know how much money the Crown Perth gave to it?
I can't recall, sorry, but it was in the hundreds of thousands annually.
And there was a representative of Crown Perth on that committee?
Yes, there was.
Do you think it appropriate that a representative of a gambling organisation be on a committee that is supposed to deal with the harm caused by gaming?
Well, from my personal perspective, I thought it was appropriate. We had the chance to discuss these issues directly with other members of the industry. And my observations was it was very, very positive in terms of their open discussions.
But in terms of you are deciding how money should be spent to minimise and treat the harm caused by, in part, casino gaming,
Yes,
and you're a representative of an organisation that promotes casino gaming.
yes.
You didn't ever see a conflict there between your position on the committee and your role in Crown?
Not specifically, but I understand your point. But me personally, I had a very clear focus on responsible gaming.
In relation to the responsible gaming management committee, is that what it's called?
Yes.
You're with the
Yes.
internal Crown
Yes, that's correct.
committee. You obviously collect it collects quite a lot of data, and you said in answer to council who asked you that the GWC or the department has never sort of, as far as you know, analysed that data to ascertain the extent of problem gaming at the Perth casino. Is that right?
Not to my knowledge. I'm not saying they didn't, but not to my knowledge. They were receiving for the last 2 or 3 years statistics that were either the same as or largely the same as some of the statistics that were presented to the Responsible Gaming Management Committee.
My question then is in respect of Crown. Did Crown use that data to analyse or measure the extent of problem gaming at the Perth casino?
No. It looked at the data in the context of trends, and there was considerable debate over the journey about the different trends. And one distinct difference between this jurisdiction and other jurisdictions, in my experience, is that the trend of greater number of problem gambling incidents with machines is not evident with our data historically. It was balanced between machines and tables. So that kind of data was looked at, and if there was a fluctuation in that, there would be a discussion as to why that would have happened, to understand if there was some intervening factor that changed, for example, a marketing campaign or maybe a new product. That level of detail was considered on not a regular basis.
Did you provide that data to any other organisation to enable it to analyse and measure the extent of problem gaming at the casino?
Not that I can recall, but specifically, I recall generally we did provide statistics to third parties. I can't recall who, but the responsible gaming team, I'm sure, did provide statistics to third parties at times.
Would you agree that there's been a deficit in the research into the extent of problem gaming at the casino? I'm not saying that that's in Western Australia. Sorry, I wanted to limit it to Western Australia. And I'm not saying that only in respect of the casino, but certainly in respect of the casino.
I agree with that entirely. That has been a constant issue when we're dealing with research that comes out. It doesn't reflect the West Australian jurisdiction, which is distinctly different.
In your letter of the 14th of November 2018, you note that Perth Casino's responsible service of gaming program was driven by Crown Perth as opposed to the regulator or regulation, which you note is what happens in at least some other jurisdictions.
Yes.
Can I ask you, and you've given evidence, in fact, in answer to a question that I was going to ask, that apart from the placement of automatic teller machines, there weren't any directions or suggestions given to you by the GWC in respect of your RSG framework?
I can't recall off the top of my head, sorry, but
And that might be a bit unfair, because in terms of, there was obviously regulation about speed of play and things of that nature.
which were a critical part of, as I understand it, each and every application that went forward for a machine or a table. That was a very key element for consideration in my experience with the Gaming Wagering Commission when they're exercising their discretion in those.
But the fact is that the GWC did not audit your RSG program.
Not that I can recall, no.
It didn't require you to have it externally audited.
No.
It didn't require you to have a responsible gaming code of conduct.
It didn't require us to, no.
It didn't require you to impose. It didn't require you to have any particular level of staff, staff numbers or coverage in terms of hours or any of that nature at the casino.
It didn't regulate us on that, no.
And in your view, would it be desirable for the regulator to do more than the GWC did in terms of regulating the casino's RSG program?
I think having RSG built into the regulation is appropriate. I think that Crown Perth was very positive in its focus on responsible gaming. Even though those things weren't regulated from the regulator, Crown Perth had set on a path pretty early on to self-impose them and continue to develop them. But regulation, I think, would be quite an important step.
Next matter is, I'm just a bit intrigued as to your view that the reduction in the speed of play from 5 seconds to 3 seconds for EGMs would not have a material effect on the extent of problem gaming or increase it. Can you just explain to the Commission again why that was your view as expressed to the GWC?
Well, when the spin rates were first set in the 80s, it was at the 5 seconds, and 5 seconds was standalone machine. So each machine, every time you wanted to spin, was 5 seconds. Over many years, machine technology had changed, and there were features, so you get free spins or bonuses. I'm not the expert in the machine technology, and link jackpot. So every single time you played, there were other things happening. It wasn't just what would be called the base game. So the analysis that the gaming product team and gaming team undertook was what is across the floor the average spin rate that Crown is currently offering to its patrons or providing to its patrons. And that spin rate was 7 seconds as opposed to the 5.
That was because other things were happening.
That's because if you're playing a game, and again, I apologise, I'm not a game machine expert, but a feature goes off, the game will add time to get a result. So it's not just the 5 second, it would be 5 second total plus the actual jackpot that might go off, or plus the free spins that might go. So it was a longer game time. Over that period, various other things had developed as well, particularly the responsible gaming framework, which back in the 80s when this first spin rate was set was most probably non-existent to any great extent. So holistically, our view, and my view was this change wasn't going to reduce spin rate to 3 seconds. The minimum would be 5, which was what historically was set. The rollout plan of these machines was over, I think it was a 3-4 year rollout time. So the change in a small number of machines could be carefully observed as to if there's going to be a change in player behaviours. So it was going to be managed, and I didn't foresee there was going to be a great impact.
But just in terms of revenue,
Yes.
the reality was that it's a revenue raising,
Yes, it would have a
Change.
positive. It would expect to have a positive impact.
and if it's raising more revenue for the casino, it means that patrons are losing more money, doesn't it?
If it's the same complement of patrons, yes.
So that raises the potential for increasing financial harm,
That's a possibility.
and financial harm can lead to psychological harm
Yes.
and social harms.
Yes, I accept that.
And in that respect, I think when the suggestion was to decrease the speed of play from 5 to 6 seconds, you'd estimated something in the range of 50 to 60. The impact on Crown would be 50 to 60 million a year. Is that right?
I think that was a revenue number.
A revenue number. Yeah, I agree with that. But if we're then talking about going the other way, you're expecting this to have significant revenue effect.
Yes, that if I recall, I can't recall the details of the submission, but for what it's worth, another element was that every single machine that Crown wanted to introduce had to be specifically designed. In that, no other machine, certainly in the Australian jurisdiction, they're all run off essentially the 3-second software. Manufacturers produce machines across all other jurisdictions, whereas WA had to have their own specific software developed. So having a change in the spin rate also assisted with the ability to get a variety of products for patrons. That's not relevant from a responsible gaming perspective, but that was another part of the consideration.
But I will finish this because I want to leave some time, obviously, for my fellow commissioners. But just in relation to the introduction of EFTPOS machines at the tables,
Yes.
that similarly increases the risk of harm from casino gaming, doesn't it?
It does in isolation, yes.
Thank you, Mr. Preston.
Thank you. Mr. Penglis, how long do you think you'll be in re-examination?
No more than a few minutes. I have only one topic to cover.
We apparently we have an issue with our transcribers. We need to break. Okay. Well, I should only be 5 minutes, I think. So we'll try and push through. Mr. Preston, I've got 3 areas that I want to raise with you, and 2 of them are really follow-ons from what Commissioner Jenkins asked you. The first is in relation to committees, and in paragraph 22 of your statement, I don't think we need to bring it up, but you say in the preamble, when you're listing those large number of committees of which you're a member, that they are committees of Crown Perth. And that's the question I want to ask you, because you confirmed to Commissioner Jenkins that they are not committees of Burswood Limited. Now, can I just give you the example? If you're on a school board or a board of a golf club, generally speaking, there will be committees, but they will be committees of the board.
Yes.
So given that they're not committees of Burswood Limited, where do you see them as actually sitting?
These are all management committees. So they all sit in and report within the management line of Crown Perth.
So to whom are they responsible?
Through to the executive and in due course through to the CEO.
Thank you. And the next area, again following on from what Commissioner Jenkins was asking, and it's about the Riverbank accounts. Now, I appreciate your evidence that you have no independent recollection of the meeting with ANZ, but nonetheless, I'm wondering if you can help me with a couple of small matters. As I understand the chronology, Riverbank was started in 2005. There were accounts with HSBC. In 2013, the relationship between Crown and HSBC came to an end, and the Riverbank accounts were started with ANZ and the South Bank accounts with CBA. So that's, and as I understand, that's July 2013. Now, by January 2014, according to the Bergen report, the ANZ Bank was raising concerns about the operation of the Riverbank account. So that's a period of 6 or 7 months
Yes,
when red flags were occurring to the bank.
yes.
Now, remember yesterday when you were shown an email from Trevor Costin to a number of people, including you, advising of the result of the ANZ Bank meetings, which was that they would be the accounts would be closed. And I don't think we need to bring this up, but in essence, in terms of action to be taken by Crown, the only matter raised in that email is that customers were to be advised not to deposit cash deposits of under $10,000, under the $10,000 reporting threshold.
Yes.
And would relevant Crown people advise the customers that? There's nothing else in the email about action to be taken. Again, I appreciate your evidence that the first time the ANZ issue was raised with you was in Bergen, and that you immediately took started the inquiries, which you've mentioned to Commissioner Jenkins. Can I ask you this, as you sit there now, either as a result of the discussions that you had after the matter was raised with you, or from any other source, are you aware of any other action taken in relation to the way in which the Riverbank account was operated that might, any changes to the operations that might minimise the chance of a recurrence of the sort of activity that the ANZ Bank had raised to your attention, or to the attention of Crown?
This was 2014.
Yes. Any change after 2014, after the accounts were closed, and again I'm asking you from your knowledge that you gained in 2019 or 2020.
No, I'm not.
You know, are you aware of any material reviews of the AML-CDF framework or program after 2014?
Well, there was the initialism review of the transaction monitoring program in 2018. There were, I think, maybe one or maybe two AUSTRAC compliance assessments in that period, and then the review process started with the joint program, initially from a legal perspective, with the planned full review upon implementation.
All right, so to your knowledge, the only material reviews after 2014 would have come from AUSTRAC compliance measures, or the initialism report in initialism review in 2018, and then into the formulation of the joint program.
Yes, save for internal audits, the work that they carried out.
All right, thank you. And the final matter is, now, we may be straying dangerously close to a question of law here, but in an exchange with Mr. Futrell yesterday, he asked you the question whether Burswood Resort Management Limited was a reporting entity for AML, and you said no, it wasn't. The reporting entity was Burswood Nominees Limited, and it was put to you by Mr. Futrell that the relationship between Burswood Resort Management Limited and Burswood Nominees was effectively one of principal and agent. Do you remember that?
Yes, I do.
And you said yes, because the reporting entity was the one that held the licence and provided the services.
Yes.
Are you aware of the, in a broader sense, and I'm only asking for your understanding, I'm not asking for a legal interpretation, that principal agency concept, would it apply generally to the relationship in a practical sense between Burswood Resort Management Limited and Burswood Nominees? What I'm really asking you is, was your answer confined to this question of the reporting entity for AML, or did it have, is it a broader operation?
My view was it would be broader, in that they were providing the services for and on behalf of Burswood Nominees Limited as the manager of the trust. That's how I've always considered it.
And just one final part of that. Did you ever read the Burswood Property Trust deed?
I did, but it would be some years ago.
Well then, are you aware that there's a provision in the Burswood Property Trust deed, and for the record it's clause 28, the effect of which is that the manager, that's Burswood Resort Management Limited, can direct the trustee, that's Burswood Nominees Limited.
I don't recall that, sorry.
Okay. If that's the case, that there's a provision in the trust deed, does that have implications for a principal and agent relationship when the agent can direct the principal?
It would seem to.
Thank you. Anything arising, Mr. Futrell?
Yes, there is, Commissioner. I will try and be brief. I will be brief. Mr. Preston, Mr. Evans asked you some questions about documents that were provided to the GWC, including records of Riverbank investments. Do you recall that? And my question really is, was it a requirement, to your knowledge, of the regulatory framework that Crown Perth provide the bank statements of its casino operating accounts to the GWC?
Yes, as I recall, it was.
And who had responsibility for the collation and delivery of those bank statements?
The finance department would collate them and provide them to me or to whoever was signing, me obviously for a period, for then distribution to the Gaming Wagering Commission.
All right, when you say the finance department, are you referring now to the local accounting team or Treasury?
Local.
All right, thank you.
Mr. Penklis.
Thank you, Mr. Commissioner. Very briefly, one topic. Now, Mr. Preston, late yesterday morning, you might not remember, I'll remind you, Mr. Futrell asked you about the workload, the transition as between Perth and Melbourne upon you becoming the Chief Legal Officer. It was put to you that when that occurred, you started doing more work on Melbourne-related matters. You responded with words to the effect you agreed with that, but the outcome was as a result of a number of matters on foot when you started.
Yes.
I'm going to ask you to clarify that for a moment. I just want to put this in perspective so that for the commission. Can we just go back to, you've still got your witness statement there.
Yes, I do.
Just want to track through your progression, if you like, as an employee of Burswood / Crown to get you to this position in March 2017. So paragraph 6, you commenced employment with Crown Perth and Burswood Entertainment Complex in the role of General Manager, Legal and Compliance. You see that?
Yes, I do.
You then, in paragraph 7, you move into, in January 2007, you move into the role of Executive General Manager, Legal Services at Crown, and you indicate what that initially included by way of responsibility. Paragraph 8, you indicate that in November 2007, you were also appointed as Crown Perth's designated AML-CTF compliance officer. Paragraph 9, you say, although you can't recall the exact dates, during your time as Executive General Manager, Legal Services at Crown, your role expanded to include all of the things in that first sentence. And you then indicate that you ceased being responsible for public relations in about 2015 and security and surveillance in about 2017. You then get appointed in August 2014, paragraph 10, as co-company secretary of the Burswood companies. You see that?
Yes, I do.
You then move into the role of Chief Legal Officer, Australian Resorts, on 1 March 2017. That's in paragraph 11. And you indicate in that role what your responsibilities included. And you indicate in the last sentence that you ceased having responsibility for security and surveillance during 2017. You indicate that in May 2017, paragraph 12, you were appointed as Crown Melbourne's designated AML-CTF compliance officer. And in 30 June 2017, you were appointed as co-company secretary of Crown Melbourne Limited and Crown Sydney Gaming Limited. Now, with that background, can I ask you this question? Apart from those roles or responsibilities that you've indicated in this witness statement, in those paragraphs, were you relieved of any other responsibilities along the way, or is that the complete picture?
That's most probably the complete picture.
All right. So, when you were appointed in March 2017 as the Chief Legal Officer, against that background, would you tell the Commission what were the number of matters on foot when you started that you were referring to yesterday?
Yes. Well, upon my commencement in early January, it became quickly apparent that there were a range of issues that I had to manage, which started with, and this was without notice to me in terms of commencing the role. An AUSTRAC assessment started pretty quickly. There was a rather large piece of work which was my original focus pertaining to reviewing the various governance structures to look for corporate structural opportunities to enhance the frameworks. There was quickly following the Section 25 review, which also kicked off in 2017, which was about a 9-month project to get the report released. There was the various Wilkie allegations, which we've discussed today, with a number of other allegations that came through with Mr Wilkie. There was another AUSTRAC assessment following on from Mr Wilkie's allegations.
What year is that? Can you recall?
That was 2018, I believe.
Thank you.
I was then asked to become involved with mechanics pertaining to the release of the staff members who had been detained in China. Also, as a result of the team, the resorts and Crown Melbourne team that were managing the China detentions, the key people had left the business. So I was responsible for assisting the VCGLR in responding to their various requests for information as they were carrying out the investigation for China. I was also involved with the class action related to China.
When you say involved, were you the person in the Crown Group responsible for providing instructions to the external solicitors in that action?
It was a combination of myself and the General Counsel of Crown Resorts.
Thank you. Keep going.
Following on from that was the implementation of the recommendations for the Section 25 review, and responding to completion of those recommendations, which was largely most of them up to and including end of F19, with some tails associated with some of the recommendations. And then the Nine and Fairfax allegations came down in just after mid-year 2019.
2019, yep.
And then from that point onwards, during that period, there was the implementation of various group roles, and enhanced frameworks were implemented across the businesses. And that work was continuing. And then I became absorbed with the Bergen inquiry, giving evidence and assisting with responding to many summons, working with the lawyers to assist the inquiry.
And when did that start, the Bergen, your work in regard to Bergen inquiry?
Well, by way of its relationship to what was transpiring, it started really the end of July when the allegations were made and published.
July 2019.
July 2019, and it finished December 2020.
Please, the Commission.
Thank you, Mr. Penglis. Mr. Preston, thank you very much. Your evidence has assisted us. There may be some tidying up to do, so we'll leave the summons in place, but you're free to go. Thank you very much. And we will resume at 10 a.m. tomorrow. 10 a.m. tomorrow. Thank you.
Yep.